Bankruptcy Trustee in Ontario, care needed to take over a claim. Introduction. As a bankruptcy trustee in Ontario, now called a licensed insolvency trustee, there are many times where our investigation indicates that the bankrupt, usually a bankrupt corporation, has a claim against another party. The claim may very well be a good one worthy of pursuing. However, like with any potential litigation, there could be not enough funds to pay for pursuing that claim in the court, or it may be unwise for a trustee to assume the litigation risk. In cases like this, the trustee can offer up the opportunity to the creditors to take on the action in their own name. One or more creditors can get an order under S. 38 of the Bankruptcy and Insolvency Act, RSC 1985, c. B3, VIA, from the registrar in bankruptcy, authorizing the assignment to them by the trustee of the bankrupt company's right to advance that claim and if necessary, sue. Without going into all the finer details, any creditor or group of creditors who obtain that right can keep any amount collected under that claim up to the total of their claim against the bankrupt company plus the costs they spent in obtaining that award. Any surplus must be paid over to the trustee. A recent decision of the Court of Appeal for Ontario highlights an interesting issue regarding the interplay between advancing such a claim by a creditor and the limitation period in Ontario. Background information. The Riedel family used an investment and stock brokerage company called EAM Investments Incorporated, EAM. In December 2006, the Riedels issued a statement of claim versus their account representative, as well as his employer, EAM. The action was for negligence, breach of contract and violation of fiduciary obligation in the monitoring of their financial investment accounts. After a 10-day court hearing, judgment was issued against EAM as well as the account representative in Riedel v. Casson, 2013 ONSC 2279. The judgment was especially scathing of both the account rep and EAM. The judgment, in the amount of $1,036,245.85, was upheld on appeal. As a result, the account representative needed to make an insolvency filing. My firm administered the successfully completed Division 1 restructuring proposal of the account representative. Given the judgment, he needed to do an insolvency filing and it was in his best interests to attempt to restructure to avoid bankruptcy. The Riedel family controlled the voting in his successful proposal. EAM filed for bankruptcy on January 20, 2015. The case before the Court of Appeal. On July 31, 2019, the Court of Appeal for Ontario released its decision in Riedel v. Goldberg, 2019 owns 636. The underlying claim was one the bankrupt company may have had against its director and majority shareholder. On October 25, 2016, the Riedels, as unsecured creditors of EAM, got an order under S. 38 of the BIA. They obtained an assignment of the claim of EAM against its sole director, a Mr. Goldberg. Since EAM was found liable under the Riedel judgment, EAM could have a claim against its director, Mr. Goldberg. The S. 38 order supplied the Riedels with the legal authority to assert EAM's claim against Mr. Goldberg to recover the damages for which EAM became liable pursuant to the 2013 judgment, as amended, in their own name and at their own expense and risk, based on Mr. Goldberg's failure to fulfill his obligations as a director and officer of EAM by abdicating his responsibility to supervise the Riedels' accounts at EAM. The Riedels launched their lawsuit in the lower court against Mr. Goldberg the day they obtained the S. 38 order, October 25, 2016. The Riedels were trying to get a summary judgment. Mr. Goldberg raised several defenses, including, the Riedels' claim was statute barred under the Limitations Act, 2002, SO 2002, Circa 24, St. B. Limitations Act. The lower court judge dismissed the Riedels' action on two fronts. First, the judge found that there were concerns needing a trial. Second, the lower court judge agreed that the claim should be dismissed because of the expiration of a 2-year limitation period. The Riedels appealed the lower court's decision to the Court of Appeal for Ontario. The fascinating part, for me anyway, of the Court of Appeal's decision. The unanimous Court of Appeal ruling agreed with the lower court judge's decision that the action the Riedels took by way of assignment from EAM's trustee was statute barred under the Limitations Act. However, the appeal court disagreed with the reasons given by the lower court. Upon agreeing that the Riedels' action should be dismissed based on it being barred by the Limitations Act, the appeal court did not wade into whether or not the lower court judge's decision was correct that summary judgment should not be granted as there was a triable issue. The arguments given for the limitation period are somewhat complex. I will attempt to summarize them here so as not to be confusing. The lower court judge held that the Rydals as applicants knew of the existence of the potential claim of EAM against its director as early as in July 2006. Since they did not launch the EAM claim in a court action until October 2016. Hence, the limitation period of 2 years made that claim statute barred. The Rydals state that the limitation period cannot have actually begun up until after EAM was bankrupt. Before then, they could not take an assignment of any claim from EAM's trustee, especially a potential claim by the company against its director. They also stated it is impossible to get an S-38 order before the company actually is bankrupt. The lawyer for the Rydals did not argue the testing of the timing of their very own understanding of the director's misdeed in regard to EAM. Rather, he focused on the fact that the Rydals were not in a place to do anything concerning it, at a minimum, until the bankruptcy of EAM. The appeal court went through a detailed analysis of the relevant statutes and case law. The Court of Appeal confirmed that the action launched was not a claim by the Rydals personally, but rather the company's claim of which they took a court-approved assignment. So the appeal court agreed substantially with the Rydals that they could not have started their action until they took the assignment from the EAM trustee when was EAM's knowledge of its claim. So the appeal court said what is important, since it is EAM's claim and not the claim of the Rydals, when did EAM first become aware of the potential claim against its director? The appeal court stated it fully understood why the director would not have had EAM sue him or otherwise enjoin him in the original claim against the account rep and EAM. However, when did EAM first become aware of the potential of its claim? On the proof in this matter, regardless of the Rydals or Goldberg's understanding of the case or his aversion to act against himself in support of EAM, at the very least, by April 2013, every one of the other EAM investors/shareholders had received a copy of the reasons for decision and judgment against the account rep and EAM. It included different referrals to the director's misbehavior. Those investors had the capacity to make EAM file a claim against the director. The Court of Appeal for Ontario judges determined that EAM recognized that 1. An injury had actually happened, 2. Its loss was brought on by an act or omission, 3. The act or omission was purportedly that of the director, and 4. An action against the director was a proper way to treat it. Regardless of the director's control to protect against such a lawsuit, the investors might have taken control of EAM's board of directors and caused EAM to make such a case versus Goldberg. So the appeal court decided that EAM first recognized that it may have a claim against the director in April 2013, but the action was not commenced until October 2016. Accordingly, it was outside of the 2-year limitation period and the action was statute barred. So what does this mean? As the trustee in corporate bankruptcy or personal bankruptcy, many times we find as a result of our investigation that the bankrupt may have a claim against another party. More often than not, we either do not have sufficient funds or are not prepared to risk the funds in the estate to the litigation risk. So, what we do is communicate with all known creditors to advise of the potential claim and that the trustee is either unwilling or unable to act upon it. Accordingly, we are giving the creditors a chance to apply to court to take an assignment of such action under S.38 of the BIA. Creditors seriously considering taking over the bankrupt's claim must seriously consider the issue of whether or not launching a court action will be met with a defense that the claim is statute barred, amongst other defenses that may be available to the defendants. The Court of Appeal for Ontario has clearly communicated that the creditor taking an assignment of the bankrupt's claim cannot be in a better position than the bankrupt itself. The first knowledge that a claim exists will be when the bankrupt first had the knowledge, not the date that the creditor obtained the right to sue or any other date. Conclusion. The business world contains normal daily risks. This case clearly shows that. Are your company's viability and solvency being threatened by claims against it, or for any other reason? Is your company experiencing financial problems? Are you on the brink of bankruptcy just like EAM was? Don't wait until it is too late to properly restructure your company's financial affairs. You don't have to be another one filing bankruptcy in Canada. As a trustee, we are the only professionals licensed, authorized and supervised by the federal government to offer insolvency advice and to implement solutions under the Bankruptcy Act Canada. We will help you to select what is best for you to free you from your debt issues. Call the Ira Smith team today so we can eliminate the anxiousness, tension, discomfort and pain from your life that your cash problems have caused. With the unique roadmap we developed just for you, we will promptly return you right into a healthy and balanced problem-free life.